Good afternoon, everybody. Thank you for joining us for the penultimate webinar in Conn Carey's 2018 webinar series. I had to look that up, and that means second to last. And I'm excited to be coming down the home stretch. I hope many of you have joined us and enjoyed our discussions throughout the year and are looking out for an announcement very soon about the 2019 webinar series. Today, our November edition of the Conn Carey webinar series will be a process safety update. And we chose this topic for November because we're coming right off the heels of our inaugural Process Safety Summit in Washington, D.C. And I see a lot of names dialed in today are folks that joined us at the Capitol Hilton in Washington, D.C. for a riveting day of process safety discussions with panels from our friends at OSHA, EPA, the CSB, and from industry practitioners, and a handful of breakout sessions. It was really a terrific program. Those of you that have process safety on your plate and were not able to join us this year, the good news is the feedback was so good about the event that we will definitely be doing a second annual Process Safety Summit in Washington, D.C. next fall. So look out for information about that and plan to join us. It was really a great day, a great event. Today we're going to talk a little bit about some of the things we heard from the regulators at OSHA, EPA, about what's going on with the Process Safety Management Standard, the Risk Management Program Rule, and some other significant developments in that area. The topics will include the status of those two sister rulemakings, updates to the RMP rule and the PSM standard, with a heavier focus on the RMP rule. If you've been paying attention, there's a lot going on there and very little going on the PSM front, but we'll update that, as well as a very significant new decision issued by the OSHA Review Commission in a major PSM case. We'll talk about what the decision was, what the implications are for PSM, the regulatory framework coming out of that. We'll also talk a little bit about the new chemical facility, petroleum refinery combined Process Safety Management National Emphasis Program that OSHA has launched, as well as some lessons learned, if we have time, lessons learned from the previous iterations of the PSM National Emphasis Program so that we can prepare for the upcoming barrage of inspections under this new inspection program. Let's do some quick introductions for who your presenters are today. The first faceless voice you're hearing right now, I'm Eric Conn. I'm one of the founding partners and chair of the OSHA Workplace Safety Practice Group at Conn Carey. I'm based here in Washington, D.C., and my practice focuses on all aspects of occupational safety and health law, from helping employers with inspections, investigations, and enforcement actions, primarily involving OSHA and the state OSH programs, but also dealing with Chemical Safety Board and EPA where there is overlap with OSHA and safety and health issues. We also handle the full range of OSHA litigation, from appeals of OSHA citations through criminal investigations and criminal prosecutions under the OSH Act. I write and speak regularly on safety and health topics, conduct training, compliance counseling, help develop and implement effective safety and health programs, and really anything at all under that umbrella of safety and health law. I'm your guy, except for my colleagues who are also quite good at this, and I'll let them introduce themselves right now.
Thanks, Eric. My name is Micah Smith. I'm a partner with the firm's National OSHA Workplace Safety Practice Group. Like Eric, I focus on occupational safety and health law, representing clients for inspections, investigations, and enforcement actions involving OSHA, whether it begins with a catastrophe, explosion, or incident, or simply just an OSHA inspection or a question that you've got. We manage that, and as Eric noted, we cover all aspects of OSHA litigation from start to finish. So happy to answer any questions you have, and glad you've joined us today. I'll pass it over to a colleague, Beta.
Hi all, my name is Beta Carey. I'm an associate at Conn Carey. Before joining the firm, I worked as an attorney investigator at the Chemical Safety Board, and now I represent employers in the full range of matters regarding the OSH Act and handle the full range of litigation related to contesting citations issued by OSHA. I also also manage inspections and investigations by OSHA, CSB, EPA, MSHA, DOJ, and state and local regulators. I'll now hand it over to my colleague, Micah, to talk about EPA's RMP amendments.
Thanks, Beta. All right, we're going to kick off this trip through process safety with a look at one of the most talked about recent developments, and that's with regard to EPA's RMP amendments. You may have heard some of this before, but we're going to, in this section, try to wrap it all up in a nice, neat little package. So buckle up, and I'll take you on a whirlwind tour of the RMP developments recently. We're going to start off with a quick review of the rulemaking for the RMP amendments. You may recall back in 2013 there was a large event in West Texas, caused a lot of consternation about the state of process safety. After an executive order was issued, a number of agencies started work on updating and reforming some of the rules. EPA committed to reform the RMP during this time period. So that all kicked off in July 2014 with a request for information related to 21 separate possible amendments to or expansions of the RMP rule. That rulemaking proceeded before, in March of 2016, a proposed rule was issued that cut down that list of 21 elements down to about 6. Of most note was the fact that that proposed rule was published before the Small Business Administration had completed its review and issued a report, and even before the public hearing was held regarding the proposal. The rush to get this out continued for the rest of the year. EPA denied extension requests at every stage, rushed the rule over to OMB, and got it out, the final rule out on January 13th, 2017, with barely a week to spare in the Obama administration. You've probably seen this before, but these are the key elements of the RMP amendments, the things that we've been talking about for a while. The requirement to have a third party conduct compliance audits for you, the requirement that an incident investigation include a root cause analysis, the addition of a safer technology and alternatives analysis to your process hazard analysis, and then a handful of things related to emergency response and public information sharing. Those are the key issues that have been keeping us worried since the RMP amendments were issued. All right, after those rules were issued, shortly thereafter the Trump administration took over. There was a definite deregulatory mood in Washington at the time. First, Congress got in on the action, attempting to repeal the RMP amendments using the Congressional Review Act. Bills were introduced in both chambers of Congress, but they did not move fast enough to meet their deadlines and actually get it repealed. Shortly after that, you had industry and 11 states petition EPA to stay or reconsider the RMP amendments. If you skip ahead a year and a half, that petition caused some consternation when it came down to a DC Circuit decision. We'll get there in a minute. After petitioning EPA to stay or reconsider the rule, in March of 2017, industry filed a challenge to the amendments in the DC Circuit. Immediately after that, in April, EPA published a proposed rule to delay the implementation until February of 2019. There were hearings and comments received on the delay rule, and then in June of 2017, EPA published their final rule delaying the effective date. We'll call this the delay rule. So just to keep everyone on track, we have the RMP amendments. That's the substantive requirements that were published in January of 2017. Then we have a delay rule, which delays the effective date of those amendments until February of 2019. All right, as soon as that delay rule was issued, it was challenged by environmental groups, and that kicks us off into about a year of litigation. At that time, the RMP amendments were fully stayed, so there was not a lot of movement. The parties were essentially waiting for the case to move through the DC Circuit. They briefed the case, had oral arguments, and then everyone waited for a decision. Now, while that litigation was going on, EPA proposed changes to the RMP amendments. This proposal was issued in May of 2018. This proposal, which they hope to finalize soon, we'll call the reconsideration rule. And the reconsideration rule is an attempt to roll back many of the substantive requirements from the RMP amendments. So we have the RMP amendments. The reconsideration rule attempts to undo that, and we'll track the delay rule separately here. All right, so while that reconsideration rule was open for comments, the D.C. Circuit issued their decision in the litigation on the delay rule, vacating that delay rule. Had one false start where they inadvertently issued the mandate, which made the completely struck down or removed the delay rule from effectiveness. They withdrew that, but then a month later, they effectively reissued the mandate permanently, making the RMP amendments effective. In that decision on the delay rule, the D.C. Circuit issued a rather scathing opinion. It was highly critical of how EPA had conducted themselves during this process, and we've included the quote here. The delay rule contains no provisions that advance or accomplish the goals of preventing accidental releases and protecting human health and the environment, but instead delays these objectives contrary to EPA's prior rulemaking determinations. It was certainly a tough decision for EPA from the D.C. Circuit. So with that, hold on to the fact that the reconsideration rule is out there with this decision from the D.C. Circuit. The RMP amendments are in effect now. They actually became effective back in October, I believe. So if you have an RMP covered process, those amendments are in effect. Shortly after the D.C. Circuit issued their decision, EPA issued some compliance guidance. It was a very short document, fairly soft. It advised on what are the current and future compliance obligations. In that guidance, they also noted that they are proposing to repeal many of the provisions. In this guidance, they highlighted the current compliance obligations. We'll highlight just a few of these because there's a number of them. Currently, there's an obligation to coordinate emergency response with LEPCs and provide information to them. There is also a requirement to include findings from incident investigations in process hazard analyses, train supervisors with process operational responsibilities, and make sure that your 3-year compliance audits cover every element of every unit every 3 years. There's a few more here, but this is a quick list of those RMP amendment requirements that are in effect at this exact moment. We'll talk a little more about enforcement in a second, but that's where we are at this moment. There are additionally some future compliance obligations that will take effect in March of 2021. These are some of the more important things, the more concerning issues for industry. I'll highlight 2 of them. The first is the requirement that your compliance audit be performed by a third party, and then also the safer technology and alternatives analysis that must be included in a PHA. Now, it's great that we have, a couple of years, 2.5 years until these become effective. If you focus on that date, what it misses is the fact that when you are dealing with these rolling compliance obligations, things like compliance audits that have to be done every 3 years, or process hazard analyses that have to be done every 5 years, a deadline for compliance that comes in 2.5 years is actually something that's more or less in effect right now. If you have a compliance audit that's due in 2019, you can do the math, add 3 years, the follow-up compliance audit won't be conducted until 2022. Are you on the hook for making sure that it's done by a third party? I think a conservative reading of the rule would say yes, it is. Same for process hazard analyses and the safer technology and alternatives analysis. If you have a PHA to be conducted next year, the 5-year revalidation won't happen until 2024, well after the compliance date. So some of these future compliance obligations are actually potentially present compliance obligations. All right, so that's the RMP amendments, the rules that are in place right now. Let's get back over to the reconsideration rule, this fun thing that's hanging out there that may make everything that I said in the last few slides completely irrelevant. So here we have listed the sections proposed for rescission in the RMP amendments, right? So these are sections, these are requirements in the RMP amendments that are in effect now or have a future deadline in 2021. These are the elements that the reconsideration rule, if finalized in its current form, would rescind and remove from your compliance obligations. You will see it includes that safer technology and alternatives analysis, third-party audits, 3-year compliance audits to cover all RMP elements in all units, a number of things related to emergency response, and then also the incident investigation updates. That includes the reviews and also the root cause analysis requirement. So we are a big chunk of the RMP amendments that you now technically have to comply with are potentially on the chopping block for removal at some point in the near future. What is the near future? What does that look like? Well, here's the timeline for the reconsideration rule. As we mentioned before, in May of 2018, that is when EPA opened the comment period on the proposed reconsideration rule. They closed that comment period in August of 2018. Just last month at our Process Safety Summit, we had some discussions with EPA personnel, including Stephen Cook, the Deputy Assistant Administrator for EPA's Office of Land and Emergency Management. They're responsible for the RMP rule. We heard from Stephen that there are a lot of comments, despite there being much disagreement on the issues that we would expect disagreement on. There was some alignment between industry and advocacy groups, particularly on issues like coordination between RMP-covered sites and local emergency response providers. So there were some areas of disagreement in the comments, but also some areas of alignment. As EPA is working through those comments moving forward, their goal for finalizing the reconsideration rule is a timeline in January or February of 2019. Now, when that hits, there will likely be some lag in time before that reconsideration rule becomes effective, but you should expect an effective date shortly after this timeline. And at that point, the provisions of the RMP amendments that we've discussed were eligible for rescission will fall out. So that's where we are at this moment. Some other important, maybe, parts of the timeline. We had midterm elections a week ago. We've seen a change, or there will be a change in the party controlling the House, not the party controlling the Senate. That new Congress will start in January. We include this on here because, anytime you have a major political change in D.C., you're never quite sure where it's going to hit. There is no affirmative, obvious way that the new Congress will get involved in EPA's rulemaking process, but it's possible that they'll hold some kind of hearing, that they'll create some noise, that they could make things a little more difficult or a little more interesting in relation to this. So we flagged that just to say keep your eyes open to see if Congress gets involved in this in any way. What happens next? All right, once that reconsideration rule is issued as final, it's almost certain that there will be some litigation to follow up on that. Having read the D.C. Circuit's decision on the delay rule, that's the Air Alliance decision, is that a sign of what's to come? The panel was very critical of EPA's actions, considering that they thought that the EPA was abandoning their mission. So is this a sign of what another panel in the D.C. Circuit or some other circuit will conclude when it's litigated? And then along those lines, when it's challenged, the reconsideration rule is challenged, will the D.C. Circuit stay that rule? So if the reconsideration rule is issued but stayed, that would mean that the RMP amendments continue in effect until the litigation closes. Those are items that are very much up in the air that will be litigated, and the decision will be made by a circuit court, most likely the D.C. Circuit. Now, while we wait for all of that, what's happening with enforcement? The RMP amendments are in effect, as we said. There is currently no clear guidance from EPA on whether those RMP amendments, all of the provisions, will be enforced or not. Many have said, why is EPA going to go out and enforce these rules that they're trying to rescind? And there's a lot of logic there. At the same time, the regional offices typically run enforcement actions, particularly at the very beginning. So there is some room for disconnect between the national office, which is trying to remove those RMP amendments, and the regional offices who see themselves as enforcing the rules that exist right now. we've seen some anecdotal evidence that the regional offices may be trying to enforce some pieces of the RMP amendments and using those amendments as a basis for opening up some enforcement actions. So will we see some soft enforcement of the RMP amendment provisions? That is to say, even though these aren't finalized, will we see EPA investigators pushing companies to implement these things, asking a lot of hard questions about why these things haven't been implemented? I think there's definitely a possibility of that. So stay tuned for the next chapter in the saga of the RMP rule, and we'll keep you posted on everything. With that, we'll flip it over to the update on OSHA's PSM rulemaking.
Hi, this is Eric. Not a whole lot to say about the PSM rulemaking on the Fed OSHA front. I'll make that very quick, but we do have some developments at the state level, and we're going to talk about that a little bit as well. So in terms of Fed OSHA's activity on the PSM rulemaking, as Micah described, sort of the origins of the RMP rulemaking coming out of the West Fertilizer incident and the executive order that President Obama issued, OSHA started the process actually even before EPA did, with its own request for information from industry to comment on ways to improve the process safety management standard. It collected that feedback, initiated the SBREFA process to get small business input about a proposed rule, and the discussion at the SBREFA level back in 2016 was focused on essentially that same 20-item list of potential changes that you might see in the PSM standard. There's an incredible amount of overlap from what the original EPA RMP request for information looked like. Of course, that 21-item list that Micah talked about got whittled down to 6 items, which is what I think they felt like they could get done in time to finish by the end of the Obama administration. The PSM rulemaking did not go through that whittling down process because it never really got beyond the SBREFA process. So there was solicited input from small businesses about that full list of 20 items, many of which are survived and were implemented at the RMP, in the RMP rulemaking, others that EPA touched on but did not implement, and that was pretty much where the rulemaking died. OSHA notoriously much slower than EPA in rulemaking generally, in particular complex health standards, engineering standards, something like PSM. There was really no chance that OSHA would be able to move as quickly as EPA, and then you ran into a new administration that did not favor advancing new regulations as much as the prior administration. So at the very beginning of the Trump administration, one of the first things that we saw from the new administration was a very different looking regulatory agenda. In fact, they renamed it from the Unified Regulatory Agenda to the Unified Regulatory and Deregulatory Agenda. So much of the focus was not on new rules that could be advanced, but on rules that were making their way through the process, being pushed back to the back burner, or new rules being promoted that would eliminate regulatory requirements. Well, one of the big changes, I guess 2 of the big changes we saw in the Department of Labor's regulatory agenda as it transitioned from the Obama administration to the Trump administration was the PSM reform rulemaking was moved to the long-term actions category, and so was the emergency response and preparedness rulemaking. That item, though, however, was restored to the active rulemaking agenda in the most recent regulatory agenda. The PSM rulemaking, however, has remained in that long-term actions bucket. So the only update I'll give here is some interesting feedback we received from Lisa Long during our Process Safety Summit last month. Lisa Long is the Director of the Office of Engineering and Safety in OSHA's Directorate of Standards and Guidance. She is overseeing the PSM rulemaking, such as it is, and she said during the summit did reinforce the idea that the PSM rulemaking is in that long-term actions category. I asked her during the panel, the OSHA panel, to help interpret that bureaucratic speak. What does long-term action mean? and there wasn't a whole lot of definition to be put to it. She said it means that they're not going to advance to the next formal stage of the rulemaking process as defined by the Administrative Procedure Act, but it doesn't mean that the rule is just sitting on the shelf collecting dust. Rather, she and her team are processing the comments that were received, both through the request for information and through the SBREFA process, and evaluating how those comments would impact a potential proposed rule if and when they get the green light, well, I should say, if they get the green light to proceed to the next stage of the rulemaking process. The other thing that she did say that was interesting was that although the OSHA PSM rulemaking has somewhat stalled in the new administration, that OSHA is actively involved in collaborating with EPA, and that OSHA was involved in collaborating with EPA during the RMP rulemaking, during the implementation of the new RMP rule, and soliciting input from EPA in the development of the PSM update. This was a pretty dramatic change in the regulatory landscape when EPA promulgated the RMP updates and OSHA did not, because there had been a historical, very close relationship between these two rules. That essentially there's guidance out there that says if you are complying with OSHA's PSM standard, that is tantamount to compliance with OSHA's RMP rule. That is not the case anymore. Expressly, different requirements under the new rules in some categories. So there is this divergence in two standards that were intended to be sister regulatory requirements. And so that collaboration is important, and it will be interesting to see what the future looks like as either the rescind rule, the rescission rule advances, or the opposite occurs and the PSM standard advances. So not a whole lot of activity under the new administration under the Fed OSHA PSM standard. Let's hear from Bita about what's going on in the various states that are making some changes in their process safety framework.
Okay, so now we're going to speak a little bit about PSM and state plan states. And as Eric mentioned, even though PSM rulemaking has been slow on the federal level, there are a couple states, California and Washington in particular, that are making a lot of movement. As you know, about half of the states in the U.S. have their own state plans and follow their own occupational safety and health standards instead of the Fed OSHA standards. And of course, those state plans must be at least as effective as federal OSHA in protecting workers and preventing work-related injuries and illnesses. So let's get started with California. Following several catastrophic incidents at petroleum refineries and after a few years of rulemaking, the Cal OSHA Standards Board approved a heightened version of its PSM rule that applies specifically to petroleum refineries. The Refinery PSM standard was approved on May 18, 2017, and went into effect in October of the same year. At the same time, the California Accidental Release Prevention Program, which is meant to prevent accidental releases that can harm public health and the environment, also issued complementary RMP regulations for refineries. So as Eric mentioned, as we've seen, unlike at the federal level, at least in the state of California, there was this parallel and harmony between the PSM and RMP rules. The Cal OSHA Refinery PSM standard was the first to depart significantly from the federal rule and includes many of the elements that went into the RMP amendments rule that we spoke about earlier. Okay, so what exactly are some of the differences between the California and federal PSM rules? First, as mentioned, the California standard expanded the scope of the federal standard. Even though the California standard applies only to petroleum refineries, it does away with setting forth specific chemicals and threshold quantities like the federal standard does. It applies very broadly to petroleum refinery activities involving highly hazardous materials, which are defined as flammable liquids and gases and toxic and reactive substances. It also applies to utilities and process equipment if they can possibly contribute to a major incident. The California standard also includes a root cause analysis element, much like the RMP amendments rule does. A root cause analysis must be conducted as part of every incident investigation. Another significant departure from the federal rule is that the California rule includes a definition for major change. Whenever there is a major MOC, refineries must conduct damage mechanism reviews, which include things like looking at cracking, corrosion, materials and construction, and so forth. Cal OSHA defines a major change as the introduction of a new process equipment, or highly hazardous material, operational change outside of established safe operating limits, or alteration that introduces new or worsens existing process safety hazards. And probably the greatest change to the California standard is this introduction of a hierarchy of controls analysis, which must also include an analysis of inherent safety measures. This mirrors the safer technology and alternatives analysis of the RMP amendments rule. California requires refinery hazard control analysis teams to sequence and prioritize their written recommendations. First, hazards must be eliminated to the greatest extent feasible under first-order inherent safety measures, then under second-order inherent safety measures. Third, they must reduce any remaining risks using passive safeguards, then using active safeguards, and last, using procedural safeguards. The Cal OSHA Refinery PSM standard also includes a management of organizational change requirement, which is something we've seen a lot at facilities anyway that follow the federal standard, but now it's actually written into the California rule. The California rule also includes a safety culture assessment requirement, which is sort of a nebulous subject. Process safety culture is defined as the combination of group values and behaviors that reflect whether there is collective commitment by leaders and individuals to emphasize process safety over competing goals. So it's something that can be subjective and at best and might not lend itself very well to enforcement. Speaking about enforcement, Cal OSHA has its own PSM unit. Just go back one slide really quick. Has its own PSM unit, which is tasked with inspecting refineries and chemical plants. It enforces occupational safety and health standards to 14 petroleum refineries in California. It has 2 offices, dedicated staff focused solely on PSM, and they also do a lot of, they're very active in outreach. One way Cal OSHA has an eye out for refineries is that it requires refinery employers to submit each September a full schedule of planned turnarounds. So you'll see on the slide that there were 4 refinery turnaround inspections in 2017. And I can just say from my experience at the CSB that we would often see the worst incidents occur during times of transition. So it makes sense to sort of emphasize this as an area to focus on. Now moving on to Washington. Washington has not yet reached a final rule, but it's getting close. Its approach has been to essentially follow the California model. It explains some of the reasons behind this approach, including practical and cost efficiencies, as well as being able to address recommendations made by the CSB related to, for example, related to its Tesoro investigation. There are currently 2 recommendations to the Washington State Department of Labor and Industries Division of OSHA that are still open from the CSB. So just going through the background of the rulemaking as well as where Washington hopes to go. It completed its first draft in January of this year, held several stakeholder meetings in January, February, March, and April. It held an open forum in the summer, and it just held a stakeholder meeting in October and will hold additional meetings. I think one of them might be today or tomorrow, but one in November and one in December for the second round of comments, which are due at the end of this year. In 2019, it hopes to finalize the language, complete a cost-benefit analysis, file a proposed rule, and file a formal adoption order So a heavy undertaking, but we'll see if following a model like California helps speed up the process. So even if you're not in one of these states, it's important to keep up to date with what's going on, because a lot of other states tend to follow, and OSHA, federal OSHA, has sort of an awareness of what's going on with all its state plan states. So always important to stay tuned. Okay, I'll now hand it back over to Micah to speak about some PSM case law.
Thanks, Beta. So you've heard a lot of, aside from the movement, which clearly there's a lot in California and Washington, you've heard a whole lot of churn and hurry up and wait with regard to the rules. In the last couple of years, while we've been waiting on all of these rulemakings to proceed or not, OSHA enforcement has continued. And that gives us the opportunity for OSHA to issue some interpretations through enforcement, and for those interpretations to be challenged. So let's talk about the one really significant PSM case that the decision was issued by OSHRC just a month or so ago. And that's in the Secretary of Labor versus BP Husky refining case. This is a case that originated out of OSHA's first refinery NEP. I think the inspection on this one actually started in 2009. During that inspection, OSHA, of course, did their thorough look at the refinery, as they did for the first round of the NEP, and in being consistent with their treatment of BP, of entities named BP, they got out their big stick and issued 42 willful findings, 20 serious items with a $3 million penalty. Now, most of the items were based on findings related to a voluntary PRV study that was done by an outside consultant. We'll talk about that at length in just a minute. But as this case was litigated, when it went to the ALJ for decision, the ALJ, Calhoun, vacated most of the citation items. I believe she left 5 in. Then the parties petitioned for review, and in front of the Occupational Safety and Health Review Commission, the case waited for a while, in part waiting for a third commissioner, which they got last year. A decision was issued September 27th, 2018. Essentially reached the same conclusion as the ALJ, gave us a little bit more information, and so we'll talk about what they found. The top line message, though, if you want to know what happened in this case, is that OSHA's interpretations with regard to the substantive requirements of PSM standard, mostly focused on RAGA-gap, those interpretations were rejected. So some of the interpretations that OSHA has been pursuing in enforcement or sometimes have been issued, the Review Commission concluded that most of those were unreasonable, the things that came up here. So that's your main takeaway, if you remember one thing about what happened in this case. But with that said, there is one particular issue that OSHA won on, or at least I'd characterize it as OSHA winning on, and that relates to OSHA's use of what the refinery called a voluntary self-audit. Now, what is it? Why does it matter? Since about 2000, OSHA has had this policy in place wherein they said that they would not use an employer's voluntary self-audit to issue citations. And so they were trying to create a safe harbor so that employers could go out, look into their own compliance, their own workplaces, and solve problems that existed. And so the idea was that they would not penalize the employer for going out and doing the right thing. So this has been a long-standing policy. There has been criticism periodically, probably continuously, throughout the history of OSHA's enforcement over the last 20 years, saying that, you have this policy, but here you are using our own documents against us. And so it's been a subject of some contention between employers and OSHA for a while. It all kind of comes to a head in this particular case because the refinery had engaged an outside consultant to do a PRV study. They were looking for compliance with API 520, trying to find out what sort of improvements or modifications they needed in their relief system. Now, this consultant issued a report, which the refinery held, They were taking actions in accordance with the findings of that report. During this inspection, OSHA requested and was given this report, and when you got down to reading the citations, you could draw a very clear path from the findings of that report to the citations that OSHA issued. I mean, for the willful items, it was nearly, you could just run them side by side and you could see what the source of most of these findings were. So the refinery argued that these citations ignored OSHA's self-audit policy, that they had, sort of promised the regulated community that it wouldn't use these documents against companies in this way. During the initial litigation in the ALJ's decision, she expressed a significant amount of distress about OSHA's use of the audit, but at the end of the day, she still considered it, still allowed it to be used as evidence. Now, in front of OSHRC, the decision was a little more clear-cut, but also very negative for the refinery. They found that the study was not actually a self-audit because it was done to update the process safety information for PRVs. And so we included that direct quote. That purpose of the report is really what OSHRC focused on, that it was to update the process safety information. The requirement to have process safety information is a regulatory requirement, and OSHRC said that if you create a report in order to comply with a regulatory requirement, then that's not a voluntary self-audit. Later in the decision, they quoted the OSHA guidance on self-audits, that a self-audit is part of a planned effort to prevent, identify, and correct workplace safety and health hazards. Now, for those of you that are familiar with a PRV study, I would challenge you to tell me in what way it isn't part of a planned effort to prevent, identify, and correct workplace safety and health hazards. It seems to fit quite squarely into that category. So there is some tension here between these two things, right? It does seem accurate that this is an attempt to update process safety information, is a regulatory requirement, but it is also part of an effort to correct workplace safety and health hazards. So what's the real takeaway here? Well, before we get to the takeaway, one main factor, and this may have been the thing that tipped it over from one side to the other, was that the employer at trial used the PRV study as evidence. And the employer's willingness to submit it into evidence seemed to give OSHRC all that they needed to say, look, you can't complain about OSHA's use of this if you're submitting it as evidence yourself. Was that a tactical error? Would this have gone the same direction no matter whether they used it or not? It's hard to say, but that does seem to be a factor. All right, so what's our takeaway here? If we can encapsulate it into one sentence, it's be careful how you initiate internal reviews and what you call them. If the refinery had undertaken this PRV study and had characterized it, maybe they had done it under privilege, and said we are going to evaluate we are going to go out and we are going to look to identify any workplace safety and health hazards in the context of pressure relief devices or valves, then it would seem that perhaps that would have made a difference, that in fact that would have been a voluntary self-audit. Would it have actually mattered? Well, we can't know, but it seems to us that when you are undertaking these internal reviews, that you should exercise a lot of caution when it comes to how you undertake them, what you call them, how you handle them. And don't be too quick to be willing to throw these things at OSHA when they show up and start doing an inspection. All right, so moving off of self-audits and back to the substantive issues of the case, there were some important decisions here. Here's a quick run of what the ALJ decided. The fact that the RAGAGAP violation was vacated because OSHA can't make an industry standard prescriptive. Employers are allowed to use internal standards. The RAGAGAP violations were also vacated because the employer is allowed to select appropriate safeguards in RAGAGAP. There was a small section of the citations that dealt with an allegation that the employer was supposed to maintain U1 reports. It's a very specific means of compliance. The ALJ vacated that citation, affirming that the employer gets to decide how they're going to compile their process safety information, that OSHA can't dictate exactly how it must be kept. The last issue that was important in front of the ALJ and was not really litigated in front of the Review Commission is that the timeline for promptly completing recommendations in a PHA is in large part up to the employer. OSHA cannot dictate a timetable for implementing those recommendations. In this case, we had an employer who had a very thorough multi-year plan to improve their facility siding. They progressed according to that plan. They implemented interim corrective measures that ensured safety. So that was a key finding there. Now, in front of OSHRC, we want to highlight two specific decisions, and we want to highlight these because these are important, and they are the things that can be cited in future cases. The ALJ's decision is important. It was positive for the refiner, but it is more important to have a decision from the OSHRC. It is much more useful when you're arguing with OSHA in the future. So, first question that was decided by OSHRC here was, can OSHA dictate the choice of RAGAGAP? Secretary argued that API 520 has two options. They set a specific percentage requirement for inlet pressure drop that is sort of set up as a prescriptive option. They also present an engineering analysis option. So API 520 says you have these two options. Here's a number that you can comply with, or if you're not going to comply with this number, do engineering analysis. Secretary argued that because the API standard didn't prescribe how to perform it, it was not available. So here you have OSHA arguing that you have to follow RAGAGAP, identifying RAGAGAP, but saying that a certain part of the RAGAGAP is actually not out there, it doesn't count. So seems to be a little bit of a problematic argument to make, and in the decision, OSHRC affirmed the performance-oriented nature of the PSM standard, saying that the most relevant source of RAGAGAP is the one on which the employer relied. So if the employer relied on a certain portion of the API standard, that's the important one. OSHA doesn't get to dictate which section of an API standard or other industry standard an employer must follow. It was important that the employer had identified the RAGAGAP and that they were complying with it moving forward. So that is key issue number one. If you're ever engaged in an inspection or a citation with OSHA where they are dictating the choice of RAGAGAP, you can fall back on this case. The second key decision here from BP Husky is the question of, is any deviation from RAGAGAP a violation of 119D3 Roman 2? We all know that industry standards are long, they are dense, there's a lot of information there, and it can be very difficult to make sure that every single piece of equipment across the refinery or across the chemical plant is completely in compliance with them at every minute of every day. Secretary argued that having a piece of equipment that did not technically comply with a design RAGAGAP, that was a violation. The refinery could implement an interim corrective measure to make sure that the equipment was being operated safely if not technically in compliance with the RAGAGAP, and that interim corrective measure could avoid a J5 or an equipment deficiency citation, but that no matter what interim corrective measures they implemented, they could not avoid the D3 Roman 2 violation. Essentially, what this would have done, if this interpretation were adopted, would have said that even the smallest deviation from RAGAGAP will establish your D3 Roman 2 violation. OSHRC held that the Secretary's interpretation was unreasonable, saying that the use of interim measures to continue safe operations is certainly allowed under J5. It is not evidence per se of a violation under D3 Roman 2. And then there in the decision they said, on its face, the requirement to document compliance with RAGAGAP applies only every 5 years. So essentially they tied the documentation of compliance with RAGGAP to the PHA cycle and said, look, you have time. If you discover a RAGGAP violation, go ahead, implement interim corrective measures, and then move forward, replace the equipment, and repair it, do document compliance with RAGGAP going forward. But we're not going to live in this world where even the tiniest deviation from RAGGAP is enough to establish that D3 Roman II violation. So this is a very, very important decision, and as I said, because it comes from OSHRC, it is something that you can use when you're dealing with OSHA. This is the reigning interpretation of how the PSM standard is to be read. So make sure that you are using this, bringing this up the next time you have a problem with a compliance officer and minor deviations of RAGGAP. So as we come back to our last section, I'm going to hand it back over to Eric to talk about OSHA's ongoing ChemRef National Emphasis Program, where you will get to engage with them again and talk about some of these RAGGAP issues.
All right, we're going to try and get you all out of here on time. So I'm going to go through what's going on with the National Emphasis Program as quickly as I can. There has been, over the last several years, two different versions of a Process Safety Management National Emphasis Program. Back in around 2015, actually earlier than that, it's been about 8 or 9 years, that OSHA instituted a Process Safety Management National Emphasis Program for petroleum refineries. And in that program, went out and inspected every single petroleum refinery in the United States except for those that were participants in the VPP program. And those inspections were very intrusive, very resource intensive. They involved this, very detailed pre-inspection questionnaire with a substantial document production and information production even before an entire team of OSHA inspectors descended on the refinery and spent months there digging deep into all of the PSM elements in a variety of different covered processes, and issued scores and scores of citations. A lot of litigation came out of that. Very, very big deal. After the refinery NEP, OSHA adjusted the program a little bit and targeted chemical facilities, chemical manufacturing facilities with PSM covered processes in a different kind of national emphasis program. It was generally targeting the same substantive areas, but in a different manner. The easiest characterization would be that the Refinery PSM NEP was a final exam, and the Chemical Facilities PSM NEP was a pop quiz. And those were sort of the language that OSHA was using to characterize the different level of resources the agency was dedicating to the inspections, and that included man hours on site, numbers of inspectors, numbers of units being analyzed, as well as the number of PSM elements being analyzed. It was more of a spot check inspection rather than a deep dive in all elements in multiple units. So that program initially rolled out as a pilot and then was mapped out to all chemical, not all chemical facilities have been visited, obviously, but it was mapped out to the rest of the country and is an active national emphasis program for several years. So what's happened since then is that OSHA has decided it's time to revisit some of the petroleum refineries that it visited during the initial round of the PSM National Emphasis Program. So rather than throw out the chemical facilities NEP and rather than institute an extremely resource-intensive national emphasis program like the first round of refinery NEPs, what OSHA has done is retooled that chemical facility NEP and combined, basically swept in refineries into that chemical facility PSM NEP. And the significance of that is that we are going to see that sort of spot check, pop quiz style inspection for refineries in the second round, rather than the very resource intensive, teams of 4, 5, 6 inspectors setting up camp at a refinery for multiple months. So the new program that I'm calling the ChemRef NEP, because it's chemicals and refineries, and that's the code language that you'll see in OSHA's data management system for tracking inspections. That's not actually what the OSHA brass are calling the NEP. It's what I call it, and I'm going to keep calling it that. So you might just hear it referred to as the Chemical Facilities PSM NEP, but I call it the ChemRef NEP because it now has swept in refineries as well. The new directive for that emphasis program was issued on January 17th, 2017. This is one of these remarkable things where OSHA had the most active week of its entire history in the final week of the Obama administration. Get as much done as you can before this new sort of anti-regulatory administration takes over. So we saw that the new EPA RMP rule the final rule was published. We saw the new directive for the ChemRef NEP was published as well. And unlike the PSM rulemaking, we've not seen the new Trump administration come in and make any changes to this emphasis program. This is one of the things that I think has survived because there is not much in the way of political leadership installed at OSHA. We're still without an Assistant Secretary of Labor for OSHA, nearly 2 years into the administration, and very little in the way of political staff at the agency. So something like this, that's not a new rule, it's not a major policy change, it's just an enforcement program, has managed to roll out essentially unchanged from what the Obama administration had planned. So the directive was issued right at the end of the Obama administration. Outreach about the new emphasis program began in the summer of 2017, and the inspections began in earnest this spring. And so we talked a little bit about the differences. I'll just highlight some of those here. This is supposed to be the pop quiz style inspection, not the final exam style of the original refinery NEP. Under the directive, it is acceptable for OSHA to use a single compliance officer rather than the minimum team of 4 compliance officers, which was actually often bigger than that under the original refinery NEP. It is possible under this new directive that only a single process unit will be selected for review by OSHA rather than the minimum of 3 and often more process units that were selected in the original final exam style refinery NEP years back. Unlike the refinery NEP, which sought thousands and thousands of pages of process safety information, full PHA, multiple entire process hazard analyses, entire sets of mechanical integrity records for big chunks of process equipment, the ChemRef NEP is supposed to be a spot check. So rather than seeing entire elements of documents that would cover entire elements of the PSM standard, the suggestion in the compliance directive for this emphasis program is that we'll see more of a spot check style request for information, so the volume should be considerably less according to the directive. There is no pre-inspection questionnaire or document request like we saw during the original refinery NEP. Instead, it's going to be a shorter dynamic question list that is not made public, again, unlike the original refinery NEP. On-site contractors will also be included in inspections under this new emphasis program. So that was what was sort of advertised, what the ChemRef NEP was supposed to look like. We'll talk a little bit about the reality now in a very small sample size of inspections that have already been conducted under the new directive. And I would say the reality has been a mixed bag. In some ways, the reality has been exactly what was advertised. I would say somewhat superficial inspections on smaller target, smaller number of elements, smaller number of units, smaller inspection team, much less documents being requested. And in other ways, it's not been as advertised. In some ways, the inspections we've seen so far have felt a lot more like the final exam style than the more superficial pop quiz style that was advertised by OSHA and as written into the directive. So the reality is that there have been multiple refineries who have been inspected now under the new directive. I would say probably in the range of about 15. I've got a list that we'll pull up a little bit later that shows all of the inspections at refineries that have been coded as ChemRef NEP inspections. And the distinction where we've seen sort of the pop quiz style inspection versus the in-depth final exam style have been the distinction between programmed inspections, those where the refinery was the next on the list, as opposed to inspections that are coded as a ChemRef NEP but started for some other reason, where the refinery had an incident, a hospitalization where they had to call OSHA, an employee complaint about process safety issues that triggered an inspection, that would have triggered an inspection whether there was an NEP anyway. Those inspections that we've seen so far, and again with a small sample size, have been pretty superficial inspections. Frankly, they've looked like exactly the kind of inspection you would inspect of an employee complaint or a minor incident without the backdrop of the NEP. They just happen to be being coded as NEP. And it seems to me almost more of a convenience for OSHA to check a box. They'll never use the word quota over there, but there is essentially a quota for a number of various types of NEP inspections, various types of other inspections that they have to conduct each year. They're coding things as ChemRef NEPs, although not conducting full NEP inspections. The programmed inspections that we have seen, on the other hand, have looked, I would say, a little bit more resource intensive, a little bit more in-depth than what we expected based on the description in the directive and based on our experience with the chemical facilities NEP over the last several years. Each of the ones that we're aware of that have been programmed NEP inspections have involved 3 or more compliance officers, teams of compliance officers that looked more like the old refinery NEP team. They were told by and in fact carried on an inspection that lasted for several months, looking more like the old NEP than the pop quiz style chemical facility NEP of the last several years. And the scope of the documents I've written on this slide far exceeded the pop quiz expectations. Let me just temper that and say they've exceeded the expectations of the pop quiz style, but they were nowhere near as extensive still as the initial refinery NEP, but they've been a little bit more involved than perhaps as advertised. One other thing that we've seen as a reality, whether it was advertised, there was sort of no mention of this at all in the directive, but it's worth noting and worth pointing out, is that the reality is that these inspections that have been done, at least the programmed inspections, OSHA is sharing the inspection findings with their brothers and sisters at EPA with the intent of perhaps triggering a sister enforcement action under EPA where the potential penalties and fines are often much greater. So we'll talk a little bit about the document and information requests. We've pulled some information straight out of the directive. We've also cobbled together some information from the inspections that have been done. Conn was engaged directly by AFPM and API to really track in depth what's going on with this national emphasis program. So we've had the fortune of collaborating with operators who have been inspected under the program so far to compare what are the requests you're receiving as compared to what is laid out in the compliance directive. And Micah has been down in the weeds with those refineries analyzing how these inspections are going, so I'll let him weigh in on this part of the emphasis program.
So what we have up here is a list of the documents that OSHA predicted would be requested. This is the screening document request. The day they show up or shortly thereafter, they'll issue this or something like this in order to help them choose which unit or units to look at. It's not a short list, but it's also not as long or involved as some of the requests from the original NEP. So you can see issues related to summary description of the PSM program, process narrative descriptions, some other overall issues. After you've received the screening document request, provided that information, they will select a unit or units to look at and issue a second document request that looks a little bit like this. You see things related to PNIDs, electrical classification classification documents, some PHAs, the initial and the most recent update, redo, or revalidation, operating limits for the selected unit, list of incident reports, things along those lines. Again, this is less involved than the original refinery NEP. So this is what's in the directive. This is what OSHA has said you should expect when you get the initial and second document request. When we've gathered some of these document requests, they've looked a little more involved than OSHA promised in their directive. So up here we have an example of a second document request that was issued. The unhighlighted portions essentially track what was predicted in the directive: P&IDs, electrical classification documents, safety systems, all things that are fairly not innocuous, but not terribly involved. But when you get down to the bottom, it starts to look a little more involved. So they asked for the initial PHA and the two most recent revalidations. They're requesting last two audit reports, including all of the follow-up documentation, a list of all contractors working in the selected unit, all pressure relief valves in the associated pressure vessel, all pressure vessels, all piping circuits, all operating procedures for the unit, and all mechanical integrity procedures. All of those alls stacked up together start to equal a pretty big stack of paper. So just beware. You should plan according to the screening document and the second document request that was predicted, but also be aware that it is entirely possible, if not likely, that you'll see a more significant document request from that. As we move on toward the end, I'll pass it back to Eric.
No, you go right ahead. So here's where we'll talk a little bit about the quota that doesn't exist. The directive does set out a strategy for the agency for how they're going to select refineries and chemical facilities to be inspected under the program, and they've got different target numbers depending on the region. And the idea would be some regions in the country have a lot more refineries, have a lot more facilities that have PSM covered processes, and so the target numbers are going to vary across the different regions. OSHA has required the state OSH plans to adopt this emphasis program, so they'll be adopting a directive virtually identical to this in California, Washington, and other states that have OSHA approved state OSH programs with covered processes in those states. And again, OSHA is sharing inspection findings with EPA to trigger enforcement actions on that side as well. Contractors included in the inspections. Here's the data that we have collected so far about known ChemRef PSM NEP inspections at petroleum refineries. The chemical facilities are continuing to be inspected like they were under the chemical facility PSM NEP, and we're going to be collecting and analyzing data about those inspections as well. But these are the new ones that are being done under the sort of retooled directive, bringing refineries back into the mix. And we've highlighted the ones that we know to be programmed inspections. They're characterized as planned inspections you'll see over on the column on the far right. The others were referral inspections, which usually means a hospitalization or referral from a report of an injury. Complaint inspections, things like that, are triggering inspections that are being coded as NEPs, but these four programmed inspections are the ones that really look like the directive has laid out, and in fact even a little bit more intense than the ones that were laid out. You see Texas, Louisiana, North Dakota, and Illinois. So we're not seeing a whole lot of activity under the emphasis program yet, but it really is just rolling out now. So one thing I want to spend just a few minutes talking about, and I've got a lot more slides than I have that I'm going to talk about, is lessons learned from the original PSM NEP. And I think that's important as we know this program is gearing up. You may be next on the list to be inspected. This is a good way for you to start to prepare for that inspection. What did we learn from the old one? The old one was very intense, 40 times more inspection man hours than the average OSHA inspection. The average penalty per inspection was $77,000, which I think is almost triple the average sort of ubiquitous OSHA enforcement action. The average penalty per violation is $7,000, and again, this was under the old penalty structure, where the maximum serious penalty was $7,000, maximum willful and repeat was $70,000, and even with that, the average penalty per violation was almost four times higher than the average penalty per violation across all generic OSHA inspections. Also seeing an average number of violations of more than 11, which is a significant number compared to the average generic OSHA violation. During the Process Safety Summit, we had Jeff Wanko with us, who is the head of the PSM program at OSHA and head of this enforcement effort right now under the National Emphasis Program. And one of the things that he highlighted multiple times during the OSHA panel, both in terms of a focus on the rulemaking as well as a focus on this National Emphasis Program, was what he called the Big Five. And it's the 5 PSM elements that get the most attention in enforcement actions. And that's mechanical integrity, process safety information, and generally speaking, application of REGA-GAP under process safety information. Similarly, with mechanical integrity, REGA-GAP was a big issue under both of those elements, as well as operating procedures, process hazard analyses, and management of change. And if you look at the percent total of the citations issued under the original PSM NEP, those 5 categories made up, I think it's 10, 20, 30, 40, it's about 75% of all of the citations issued under the Emphasis Program were issued in those 5 categories, or the Big Five, as Jeff pointed out. So again, that's, whether that means employers are getting it wrong most often in those categories, or what I think is more likely, that's the low-hanging fruit that OSHA compliance officers are trained to focus on and understand perhaps best and are best able to cite. That's an area where it makes sense if you're going to apply some resources preparing for a visit from OSHA under this new Emphasis Program. Those 5 categories would be a good place to spend some time and spend some resources. Some other lessons learned from the prior NEP. OSHA's takeaway is that a list-based approach finds lots of hazards. And the list-based approach was sort of the dynamic, or at the time it was sort of a fixed list of topics, fixed list of records and information requests, and a fixed list of ideas or concepts to target in the inspection. And they found that that list was a very effective way to conduct the inspections and find and cite lots of violations. COSHO training created PSM-capable inspectors. There was, we talked about teams of 4 to 8 inspectors during those inspections. Many of those were trainees who were becoming PSM-knowledgeable inspectors, and by the end of that program, OSHA felt like their stable of PSM inspectors had greatly improved, and the quality of the inspections had greatly improved. OSHA focused heavily on REGA-GAP and whether employers were relying on appropriate REGA-GAP, whether they were complying with REGA-GAP that they selected, and that focus yielded many deficiencies. And that's one of the things that Micah talked about in the BP Husky case. OSHA treating REGA-GAP as mandatory and really substituting OSHA's own judgment for employers' judgment about which REGA-GAP it would select and how to comply with the REGA-GAP that they've chosen. And then another finding or takeaway from OSHA that they announced after the original NEP was the refineries still have a lot of facility siting issues, or they did at least during that round of inspections. And they were focused on that because, of course, the very significant other BP inspection arising out of an incident in Texas City, where the facility siting issues were a core focus of that incident and enforcement action. So OSHA was focused on that in the original round of NEPs. One of the interesting takeaways from the albeit small sample size of new NEP inspections that are being conducted is that OSHA is not finding the facility siting issues in the same degree that they were finding previously. which one would expect, right? The BP Texas City incident occurred not long before the NEP historically, and facility siting issues are not the sort of thing where you just update a procedure and you're good. That takes some capital investment, so it makes sense that we're seeing significant improvement in the area of facility siting between the two NEPs. I'm going to send to everybody who's registered for this webinar a copy of these slides, so I'm not going to go into detail these particular lessons learned, but this was all pulled from a lessons learned document that OSHA issued, strangely many years after the refinery NEP, but just in time for the launch of this new ChemRef PSM NEP. And they went into detail about not only, it's one thing to say, hey, the big five were problematic at the refineries that we inspected. The lessons learned document actually went into sort of a deep dive about what were the specific sub-issues under the mechanical integrity umbrella that were frequent findings during the original NEP inspection. And it talks about how they were using Reg A-Gap to cite violations during the original NEP. So there's good lessons to be learned here. I'm not going to go into detail on these just because we don't have time, but you will get a copy of these slides. And if you have questions about what any of this means, please don't hesitate to reach out. And we cover sort of the subtopics under process safety information, under PHAs, under standard operating procedures and shutdown procedures, safe work practices, and management of change. Lots of good little lessons to be learned in there for how to improve your program and how to prepare for another visit from OSHA, as well as some other key findings, things that were not necessarily under 1910-119, but were being found somewhat frequently during the NEP inspections. These are things that I think we can fully expect to also be major categories in the new NEP as well. It's electrical classification and electrical safety issues. A big focus in the original inspections was controlling equipment that enters those areas, enters covered process areas, including buildings, within buildings, or vehicles that are moved into classified areas. Hazard communication continues to be a big focus. On a PSM NEP inspection, you can expect to find HAZCOM issues, and especially I think now, since the hazard communication standard has been updated between the two NEPs, you might expect for OSHA to focus even more on the level of compliance with the new elements of hazard communication at refineries and chemical facilities visited during this round of NEPs. Similarly, PPE, personal protective equipment issues, were identified somewhat frequently during the original round of NEPs, and that's something that we can expect OSHA to continue to look for, that kind of low-hanging fruit at refineries and chemical facilities as well. The last thing I would say here, I guess I covered this already, was that at our Process Safety Summit, Jeff Wanko talked about that big five, but he did report that based on the early findings, the early returns from the few ChemRef NEPs that have been conducted, is not only what I said before about fewer facility siting items, but in general, fewer items even in that big five category. The big five continues to be the most frequent cited topics within the PSM universe, but he's seeing, or OSHA is seeing, smaller numbers of violations in the inspections they've conducted. We've even seen some inspections completed without any violations being issued, which I think was completely unheard of in the original round of inspections, but now we're seeing more and more inspections like that, or with many fewer inspections, not the 11+ average that we were seeing during the original round of inspections. So maybe it is going to be more of a pop quiz type of review. The early returns suggest that that is the case. So that's our process safety update for 2018. I usually at this point encourage everybody to sign up for all of the remaining webinars in the series, but there's only one left. And it's a really interesting crossover topic with our employment colleagues here at Conn Carey. It's about OSHA and the Americans with Disabilities Act, how these two labor laws often align and sometimes diverge in areas related to worker safety and disability issues. So I encourage you to sign up for that and look out in the next couple of weeks for the announcement about the 2019 OSHA webinar series. We've almost finished pushing the boulder up to the top of the hill. We'll let it go and it'll roll back down to the bottom, and we'll start over again with this exciting effort of putting together really in-depth OSHA programs for you each month. We really enjoy it, and I hope you have as well this year, and we hope you come back for more next year. Also encourage you to check out our OSHA blog, the OSHA Defense Report, www.OSHA Defense Report. Lots of great updates on there, including lately a lot of meaningful process safety updates, because so much has been going on with the RMP rule and some of these OSHRC decisions. So interesting stuff on there. With that, I'm going to wrap it up for the day, because my office is about to host our annual Thanksgiving dinner here in the office. So this has been a great warm-up for that, and we've enjoyed spending time with you all. I'm not participating in the last webinar of the year, so my jury duty is done for the year, and thank you everybody for joining us for this one and all the others before it, and we look forward to talking with you again next month and next year.